family law judge keeps making orders before the court date. What do I do? I'm also Attorney James Worth. That's the question that we have. Sounds like we got somebody in a family law court in the state of Oklahoma going through a proceeding. We don't know whether it's a divorce proceeding, paternity proceeding, or even if it's a potentially guardianship or something other proceeding, but it sounds like it's probably a divorce or a paternity proceeding. They've got a court date set and they feel that the judge keeps making orders before that court date and want to know what they should do under those circumstances. So first off, there's a lot of different things that could be going on here. There's a lot of different types of family law cases, a lot of different stages of family law cases, a lot of different relief that somebody could be requesting that's being granted. And without knowing what category it falls into, we don't know exactly what we need to do. So the best advice to you, obviously, is get with an attorney that can look at your specific circumstances. But I do have some general information I can provide. Under Oklahoma statute, there's district court rules. You can find them on oscn.net. And you find the Oklahoma statutes, and it's in Title 12, and then under Rule 4, motions. And it has a list of different motions that say when you file this type of motion, you need to include a brief and authority. Generally, when you file a motion, you need to include a brief of why you're entitled to it and authority, but for this list, you're not required to. And then for that list there, generally, you don't have to necessarily file a responsive pleading. These types of ones, things that are on this list, we see commonly are granted or denied without a hearing. That's motion for an extension of time, motion to continue, a hearing pretrial, a motion to amend pleadings, motion to appoint a guardian ad litem, motion for physical or mental examination, motion to add or substitute parties, motions to enter or vacate default judgments, motion to confirm sales, motion to stay proceedings, motion to shorten this prescribed time period, motion for scheduling conferences. So all of those types of one, it's normal for the court to grant those without a brief, without authority, without a hearing. However, if we go further down in that same Rule 4, we can go down to subsection H, and it says this: motions may be decided by the court without a hearing, and where this is done, the court shall notify the parties of its ruling in writing by mail or email. So it is not required to have a hearing on every type of motion, and how you resolve that depends on what type of motion it is. So what you could do is you could request a rehearing on it, even though there was never a hearing. The fact that the court decided it without a hearing, you can file a motion for new trial, motion for rehearing to get it before that judge. If you want to do that, you want to do it within 10 days, get it set on that court's docket, allowed to be heard. Depending on what it is, it may be an appealable order. So it may be something that you can make sure that there's proper documentation on the court's ruling, final order, journal entry been entered. And if it's a final order like that, then you may be able to appeal it to a higher court, such as the Oklahoma Supreme Court or the Oklahoma Court of Civil Appeals. But without knowing exactly what you're dealing with, it's tough to say. But a lot of times, if we're talking about, family law, divorce cases, these could be temporary orders, and there's not a lot of oversight as far as appealing those to a higher court. And the court may not want to have a full-blown hearing on some, temporary order issues, so you may not be able to get in there. But the reason why is because that's not a final order. It's only temporary. It's going to be superseded at some point, either by dismissal of the case, in which case it goes away, or by a final order after a trial or after an agreement on all terms. So particularly busy courts like Tulsa County, where they have a lot of issues coming before them, they don't like to do a lot of litigation on temporary orders, or certainly they don't like to have multiple temporary order hearings. They get temporary orders in place, and then if you want to change those, they're going to push you, well, then move forward to a final trial, a hearing, where you get your full due process, where you're going to have a hearing. It's going to be an evidentiary hearing. You get to call witnesses. You can compel people to testify. You can cross-examine the people against you. You can bring in your evidence. So that's usually the way those things proceed, but how it's going in your case and whether your rights are being violated, we're going to need more information for that. So do talk to an attorney about your specific circumstances. And anybody else listening to this, if you're going through this scenario, general information is great, but it doesn't beat talk to an attorney privately and confidentially so you can receive legal advice, strategic planning for what to do in your case. To talk to an attorney at my office and get that scheduled, you can go online to makelawEasy.com.